appointment as a temporary CPC, Your Lordship.
No, sir. From 15/12/1992, he has a permanent status.
But he has not joined the letter was issued
He
in
did not join, sir. He was already working.
6 to 1993, Your Lordship.
Not retired, he died.
He died, Your Lordship.
This,
Lordship.
18/11/2014 was not challenged by him.
18, that was challenged, Your Lordship.
Challenge in which petition?
Next page.
Railway petitioner filed the writ application in 2018. In 2020-22, they have issued a letter to the widow who has respondent herein to fill up all the paper for grant of family pension. She complied the orders, they have approved the family pension. Kindly, Your Lordship, in spite of that, they are not releasing
Was
it.
not approved, Your Lordship.
All right, forget about all those things.
Lordship.
How the respondent is not entitled to family pension.
Lordship, the deceased employee was joined as a Khalasi, temporary Khalasi in 1979, Lordship. In 1979, Lordship, one order was given to him for medical examination, Your Lordship. That is Annexure 1, Your Lordship. He said that medical department, third role, certificate of physical fitness of candidate, Lordship. Here the medical officer says that I do not consider this is a disqualification for employment in the branch department, Lordship. In 1993, a scheme was to decasualize the casual laborers, Your Lordship, with effect from 15/12/1992, Your Lordship. So the order was given on 1/6/1993, Your Lordship.
Posting order was given.
Lordship.
Posting order was given on 1/6/93.
93, Lordship. So decasualize the scheme with effect from 15/12/1992. In the meantime, Your Lordship, from 1/3/1993 to 30/6/1993, he was on leave. He had not joined the post, Your Lordship. And he died on 30/6/1993, Your Lordship.
Not retired, he died.
He died, Your Lordship. In the meantime, after 20 years of gap, the deceased employee's wife, Lakshmi Devi, filed OA before the CAT, Your Lordship, Patna bench. The CAT Patna bench observes with the directions given to the railway authorities that was decided on 18th November 2014, Your Lordship. The operative part is that, Your Lordship. Last paragraph, Your Lordship. May I read, Your Lordship? It is also noted that death of husband of the applicant occurred in 1993 and the applicant has filed OA in 2013. There is no explanation for delay in filing OA. Learned counsel for the applicant has argued that clause.
So where are you reading?
That is Lordship order sheet of
Sir, para 1 to 11 of the CAT order.
para 11, Your Lordship.
Para 11.
Lordship.
OA is allowed. In conclusion, the OA is allowed.
OA is stand dispose of. OA of Lordship 351 of 2013, Your Lordship. It was disposed of on 18th of 2014. First OA, Your Lordship.
No, where is that order? First OA, second OA.
First OA, Your Lordship.
And with OA number 675 of 2006.
Prior to that, Your Lordship, one OA was filed after a gap of 20 years in OA number 351 of 2000.
Where do you get that document?
It is filed before the CAT, Your Lordship.
This one? Yes. No, this is written. Yes, sir.
OA 351 of 2013.
This is 675.
Lordship, got the
Which year OA? 2013.
Lordship.
Huh.
351 of 2013 disposed of on 18th November 2014, Lordship.
Huh.
Your Lordship got the order.
Read.
Lordship.
Why two OAs filed? One is OA 351 of 2013 is for what?
For all consequential benefit, Your Lordship.
Huh.
That was on page 5 of the order sheet, Your Lordship, paragraph 11, Your Lordship.
Huh.
It is also noted that death of the husband of the applicant occurred in 1993 and the applicant has filed OA on 2013. There is no explanation for delay in filing OA. Learned counsel for the applicant has argued that clause of family pension is continuing cause of action and non-payment of same as well as other settlement dues is not hit by limitations. In this connection, this tribunal has in the number of cases clarified that while current pension may be continuing cause of action, but areas of pension / family pension and other settlement dues do attract limitation because of those claims. The cause of the action arises at the time of retirement, death, and sanction there is one-time action, not a continuing cause. As such, I do not agree with the counsel for the applicant so as the claim of the areas of family pension settlement dues are concerned. Hence, if the settlement dues or family pensions are found admissible, no areas of family pension and interest on settlement dues shall be paid if the payment of such admissible dues is made within 6 months from the date of receipt of the copy of this order. It is of the delay further that interest at simple rate is 8% per annum. This OA is disposed of. After that, Your Lordship, the Railway Authority gone through the file, Your Lordship, and the respondent 4, Your Lordship, Senior Division Personnel Officer, passed the order in which it was denied the family pension, Your Lordship. Next page, Your Lordship. Order sheet, next page.
No, this
Lordship.
18/11/2014 was not challenged by him.
18, that was challenged, Your Lordship.
Challenge in which petition?
Present.
Next page.
That was challenged in the press web, which is under challenge.
675 of 2015, Your Lordship. OA number.
No, sir. The OA is OA 351 of 2013. Decided on 18/11/2014.
Lordship.
It was subject matter of writ petition.
No. Then the subsequent order was passed by the respondent 4, Your Lordship.
Where is that order?
Next page, Your Lordship. Compliance of order passed by Honorable CAT Patna in OA number 351 of 2013, Lakshmi Devi versus Union of India and others. Dated 24/4/2015, Your Lordship. Lordship got there?
Yes.
Relevant the applicant Srimati Lakshmi Devi has filed such and such before such and such for family pension payment of settlement dues. The record pertaining to the case have been examined and observed as under. The husband of the applicant's late Sushil Gangman Kuhl died on 18/6/1993 while in service as CPC, contingency paid Khalasi, Your Lordship, casual Khalasi. CPC is contingency paid casual Khalasi. He was contingency paid casual Khalasi who died without regularization in the service.
No, regularization has been given with effect from 15/12/1992.
Lordship.
Why it has not been,
The letter was.
he not entitled to regular pay scale or a pay
Lordship.
with reference to Khalsi with effect from 15/12/1992.
Lordship, the letter was issued into
All right, 93.
Lordship.
Ah,
He has not.
retrospective effect, no?
But he has not.
Correct. If it is a prospective effect, what you say is correct. If it is given retrospective effect, you are bound to.
But he has not joined the permanent.
That is immaterial. Then what is the object of giving retrospective?
But the moment he will join Your Lordship, then he will declare as a permanent Khalasi, Your Lordship.
Oh, sir, sorry, sir.
It transpired that the late Sushil was on leave without pay on 1/3/1988 till his death. This means that he could not join the regular post of Khalasi at Mokaba against order number 16/1993, Your Lordship. So he has not joined the permanent post, Your Lordship. This means that his status was remained as a temporary CPC, Your Lordship.
No, sir. From 15/12/1992, he has a permanent status.
But he has not joined the letter was issued
He did
in.
not join, sir. He was already working. Assuming that he was working as on 15/12/1992 on casual basis.
Lordship.
On that day onwards, he will be regular.
With effect of letter. The letter was issued on 1/6/1993.
93, yes, let it be. Then why you have given effect from 15/12/92? If it is prospective, what you say is correct. If you are not mentioned 15/12/1992, then your argument could have been accepted, stating that he has not assumed the duties of the post after regularization.
But he has not joined the substantial post, Your Lordship.
Sorry. Anything else?
That was challenged before the CAT on next subsequent CAT order.
Which is the subject matter of the present petition.
Sorry. One judgment is there. One judgment is there, Lordship.
Judgment.
2008, Volume 2, SCC 108, Your Lordship. May I read the placitum, Your Lordship?
What is?
Nidhi.
Paragraph.
Paragraph, Your Lordship. Paragraph 31, 32, Your Lordship, and last paragraph 34, Lordship.
31, 32.
Yes, Lordship. That High Court allowed, Your Lordship.
Yes.
Meantime, Your Lordship, the deceased employee wife was given
No, sir. 31 is what? Gujarat High Court.
to the High Court.
Read it. Starting.
The placitum clears, Your Lordship.
Whether Chanda Devi's husband was regularly appointed.
He was
Gujarat High Court had given direction to include his name for absorption. That is not the issue here.
When the railway pension rule Milad supports 18(3) Milad.
Huh?
The railway pension rule clearly shows Milad. I am reading page para rule 18 subclass 3 of the railway pension rule.
Pension rules.
Milad.
No, they are not disputing. You are entitled to or not. Their question is that you are not a permanent employee.
This on this particular point the railway pension rule I am reading Milad. in the event of death in harness of a temporary railway servant, his family shall be eligible to family pension and death gratuity on the same scale as admissible to families to a permanent railway servant under the rules. This is railway pension rule. Sir, 18th. And now they have, if you have peruse the letter just I have given me, lad, they have already sanctioned, they obtained all required paper for grant of family pension in 2020-22. I submitted, the competent authority senior division personal officer has approved, but now they have kept pending because the matter is pending.
Just because contempt was filed, so the department moved that.
22 में आपका
No, this is instructions.
pension rule, this is railway pension rule.
Where is the title of the pension?
In the very first page, sir, just I am showing you. Railway pension rule 1993.
Anything else?
Good.
It's taken. Petitioners dash Department of Railways have assailed the order of the CAT dated 28/8/2017 passed in OA 675 of 2016. Page number 2 missing 8. Respondents, brief facts of the case are that respondent husband, deceased Sushil, was appointed as a casual laborer in the year 1979. He was subjected to medical examination for appointment of Group D post on permanent basis. Even though he was process of providing Group D permanent status has not attained finality for no reasons. Thereafter, petitioners, railway authorities evolved a scheme called decasualization. So, under such a scheme, the deceased was working as working with the status of a temporary khalasi, was made permanent with effect from 15/12/1992. Such permanent status with the retrospective effect has been ordered on 1/6/1993, and he was given at QUL, KIUL. So he could not reported for duty, maybe due to illness, and he died on 18/6/1993. This backdrop, petitioner Srimati Lakshmi Devi, wife of deceased Sushil, has been denied retirement benefits and pensionary benefits. In this regard, the petitioner filed OA number 351 of 2013, and it was decided on 18/11/2014. Thereafter, on 24/4/2015, in the guise of compliance to the order dated so and so, passed in OA number 351 of 2013, claim of the petitioner was rejected. Feeling aggrieved and dissatisfied with the communication dated 24/4/2015, the petitioner filed OA number 675 of 2016, and it was decided in her favor on 28/8/2017. Hence, the present writ petition on behalf of petitioner department. Next, Parliament Counsel for the petitioner vehemently contended that the tribunal has committed error in not appreciating the giving effect to the decasualization order and posting order to deceased Sushil remained absent from 1/3/1993 till his death. Therefore, he has not occupied the post of not occupied the post with reference to his status as regularly appointed / a permanent appointment, and failed to join at a transferred place, namely Mokkam. The aforesaid contention is not appreciable for the reasons that CAT has taken note of the aforementioned contention and considered in para 9 to 11. Next paragraph. Petitioner, being a model employer, should be fair enough to treat a petitioner who is a legal heir of a deceased employee who has rendered service from the year 1979. In all fairness, the concerned authority should have extended the benefit of retirement benefits and family pension insofar as the retired benefits is concerned, the earlier OA number 351 of 2013 has attained finality. Full stop. Now the question for consideration is only to the extent whether petitioner is entitled to family pension or not. Full stop. It is not that deceased Sushil was given a permanent status with effect from 1/6/1993 so as to contend that he remained absent from 1/3/1993. On the other hand, permanent status has been granted in favor of the deceased employee, deceased Sushil, with effect from 15/12/1992. To stop. As on the 15/12/1992, he was very much in service, and he has been assigned permanent status with effect from 15/12/1992. Therefore, one cannot draw inference that remaining absent with effect from 1/3/1993 till his death would result in he died while holding the post of while holding the temporary status. So once he has been granted permanent status with effect from 15/12/1992, in the result, respondent is entitled to family pension in the light of order passed in OA 675 of 2016. Full stop. Next paragraph. We feel to modify para 11 of the CAT order passed in 675 of 2006 to the extent that respondent is entitled to interest at 8% per annum from the date of 3 years prior to filing of original application OA number 351 of 2013. In the light of Apex Court decision in the case of M.R. Gupta versus Union of India 1995, so and so, read with Apex Court decision in the case of Vijay Mehrotra versus Union of India 2001 9 SEC page 687. Full stop. In other words, the respondent is entitled to interest on belated arrears of family pension three years prior to filing of OA number 351 of 2013. The same shall be calculated and disbursed in favor of the respondent within a period of 3 months from the date of receipt of this order, failing which petitioner is respondent is entitled to litigation cost, and it is quantified at rupees 50,000, for the reasons that she is before a judicial forum for almost 1 decade. LPA stands rejected.
Repeat.